What's the difference between environmental law and environmental policy? If you have ever wondered about the distinction between environmental law and environmental policy, you are not alone. Many people find these terms confusing, especially in the context of law school. Let's break it down clearly and simply. Environmental law is essentially a set of rules and regulations that are designed to protect the environment. These laws are enforceable and can be upheld in court. For example, the Clean Air Act and the Endangered Species Act are two significant pieces of environmental law in the United States. They set specific standards that individuals and organizations must follow to ensure the protection of natural resources and public health. On the other hand, environmental policy is a broader concept. It encompasses the goals and strategies that guide decisions related to environmental issues. And like laws, policies are not always legally binding. They provide direction for how laws and regulations might be developed in the future. A good example is the National Environmental Policy Act, which requires federal agencies to consider environmental impacts before making major decisions. However, it does not impose specific legal requirements on private entities. Now, let's look at some key differences. First, environmental law consists of legally binding rules that can be enforced through courts or regulatory agencies. If someone violates these laws, they could face penalties or fines. In contrast, environmental policy influences lawmaking but is not enforceable unless it becomes law. Next, consider the scope and flexibility. Environmental policy is generally broader and can adapt to new scientific findings or changes in political priorities. Environmental law is more rigid, with clear standards that must be followed. The development process also varies. Laws are created through legislative processes and can be challenged in court. Policies are often developed through administrative processes and can be revised more easily based on new information or public opinion. For law students, studying environmental law means analyzing statutes, regulations, and court decisions. They learn how these legal rules are applied and enforced. Environmental policy is often covered in broader courses on public policy or administrative law. Students examine how policies are developed and how they influence lawmaking. Top environmental law programs typically offer courses that cover both law and policy. This dual focus prepares graduates for various careers, whether in government, nonprofit organizations, or private practice. Understanding both areas is essential for anyone looking to specialize in environmental issues. In summary, while environmental law and environmental policy are closely related, they serve different purposes. Law provides enforceable rules, while policy guides decision-making. For students in law school, mastering both areas is key to making a positive impact in the field of environmental protection.